Mr. Chairman, I do apologize for my oversight. Whenever I asked them to reback this bill was going to be part two. I had tried to get it across the finish line last year. Unfortunately, with COVID and everything, it did not make it. So whenever I asked them to reback the bill, I just kind of presumed, and that was my fault, that they had just followed the language that I had provided from the former LC number. It looks like they did deviate quite a bit from that. There are some parts that obviously need to be changed to get it back to the original LC. So at this point, I'm going to have to ask, with the chairman's indulgence, to suspend on the hearing. I'll get the changes made and alert the chairman and yourself as sub-chair when we're ready for a hearing, if that's acceptable to the committee.
That's acceptable. You just let us know.
Okay.
You get it fixed.
I certainly appreciate it.
All right,
Thank you.
Thank you very much. All righty, let's just move on. Let's see. I believe we have Representative Kendrick. We're going to do a hearing only on HB 438. You got that?
Thank you, Mr. Chairman and members of the committee. I am bringing for your consideration HB 438. And before I explain a little bit about this bill, this is an accountability bill for our law enforcement community. I think we all want accountability, so I don't want this to be seen as anti-police. But what HB 438 does is it allows for POST, which is the certifying entity, and we have the executive director here, Mr. Ayers, if you have any questions, but allows for him through his emergency suspension order to be able to take law enforcement officers under that order that have done something egregious under that order and to place them on administrative duties. And you'll see in the legislation that it lists out is exactly what those law enforcement duties are. So essentially taking them off the streets and to desk duty during the pending investigation. So they are not fired, so we're not violating any due process, but obviously I think we can all agree that for egregious crimes or alleged crimes, we do not want police officers to have the same law enforcement powers that they had before the allegation. There is a letter that should be in your packet from POST, Mr. Ayers, and also from the Southern Center for Human Rights, as well as an email from the police chief saying they do not oppose this bill. I've contacted the Sheriff's Association several times and cannot get a response back, but I have reached out to them. And if anybody wants to know a little bit more about that process, I think some people had some questions about the process. He would be the expert on the process, but obviously if you have any questions about the actual bill, please let me know.
Okay, hold on. Let's see if we got any questions. You have any questions? I think we have one from Representative Taylor.
Thank you. Just a couple questions, and I know we have talked about this bill, and it has some great parts to it. Was there already something called an emergency suspension, or is this a new, there already is one in statute?
Yeah, what we're doing is taking that emergency suspension power and actually giving it teeth.
Okay, so if this person qualifies, this is what happens, and the officer will be suspended under that category. And is it with or without pay?
Okay, yes, please.
Thank you.
Could you tell us who you're with and
Absolutely.
your name, please, sir? I'd appreciate it.
Mr. Chairman, thank you, committee members. My name is Mike Ayers. I'm the Executive Director of the Peace Officer Standards and Training Council. And if you would, I'd like to back up and just give a little bit of background to this because I think it will clarify a lot of our questions. First and foremost, this applies only to those situations in which an officer is charged with a felony. Okay, so it has nothing to do with officers who conduct lesser instances of misconduct. So these are serious crimes in which they could be punished as for a felony. Under current Georgia law 35-8-72, the executive director of POST has the authority to sign an emergency felony suspension order for someone who has been charged with a crime that constitutes the level of a felony. That suspension order stays in effect until it is either lifted by the executive director or until it reaches this term referred to as final action that's in the bill. And this seems to be the problem in defining exactly what final action is. And that's the reason why I've reached out to Representative Kendrick and asked her if she could help me with this. Under House Bill 438, we seek to clear up this issue of what constitutes final action. Ever since this law has been in effect, if you'll indulge me a minute, I would like to explain to you kind of how the current process has been working. An officer is charged with a felony. We receive notification of that, and my staff prepare an emergency suspension letter that I sign. Generally speaking, when I say felonies, this deals with officers committing, again, serious crimes or smuggling contraband across a guard line, something of that nature. Once I sign that, they are not able to work in law enforcement at that time, period. I take away their powers at that time. That has been on the books for years now, and it's the way that it has been done. We conduct our own independent investigation through my investigators, while the district attorney's office and the local law enforcement agencies that are investigating this charged crime continue through their process. At some point in time, the district attorney will either make a decision to prosecute the officer, or as we all know, sometimes the crime may be a legitimate charge and not be prosecuted. I'll give you a great example of that, and that would be smuggling contraband across a guard line. That is a felony to bring dope into a prison, or to bring cell phones or anything else for that matter. But oftentimes those charges do not go prosecuted. So the problem that we run into with that is the council, because we operate under a preponderance of evidence as opposed to reasonable doubt, we have the authority to continue to impose a sanction upon that officer, even if the district attorney chooses not to prosecute, or even if, for that matter, if the person is acquitted. We have that, we can look at those items of evidence ourselves. Once we compile our investigation, then that investigation is given to what is referred to as the Probable Cause Committee. And that is a committee that is composed of members of the council. And as you know, the vast majority of those council members are law enforcement executives or governmental executives that are appointed largely either by statute or by the sitting governor at that time. They listen to the facts of these cases and they make a recommendation. And that recommendation can be anything from taking no action at all to revoking their certification. That recommendation is then forwarded to the primary council, who meets quarterly, and they vote on what to do in that situation. So this is where the rubber meets the road, if you will. It has been the opinion in the past of the Attorney General's office that that final action occurs when council makes that decision. So let's say council decides that they wish to revoke this person, take their certification away from them. At that moment, under the current system, that emergency suspension order that I signed falls off. Then that officer can go out and get another job in law enforcement, file an appeal, and through his own actions or the actions of his attorney can drag that out, sometimes for years. And they're allowed to continue to work. I'll give you a great example. Gwinnett County had an officer charged with child molestation. We revoked him. He files an appeal and goes right down the road to a local department and gets a job in law enforcement. I don't think any of us want that to happen in the future. So speaking with the Attorney General's office about this, they've done additional research, which may make our whole point here moot. But again, I have to thank Representative Kendrick because we would have never got this far otherwise. But if you'll indulge me, I'd like to read their opinion on this process now. It says, according to Georgia Post Counsel, the decision is final if the decision of the administrative law judge is the same as proposed action of post. In such instances, The decision is final, subject to the appeal of Superior Court. Where the decision of the administrative law judge differs from the proposed agency action, a review of the hearing record is conducted by the Georgia Post Council. Also, Georgia Post Rule 464-8-06 states that any initial decision of the hearing officer, which is identical to the council's initial action, becomes the final decision of council. So you see now we've shifted from the initial decision of council till now we're at the end of the appeal process, which is where we need to be. And go ahead,
Excuse
Matt.
me, is he interpreting it that that's what the law is really saying? Is that a new
Yes.
interpretation?
Yes,
Okay.
ma'am.
Thank you.
Under Georgia Comp R and Regs R 464-8-06, additionally, in Bennett versus Spear, the Supreme Court had that generally two conditions must be satisfied for an agency action to be considered final. First, the action must be marked the consummation of the agency's decision-making process. It must not be merely tentative or interlocutory in nature. If a decision can be made by OSA, triggering a presentation to council and another vote, it is not consummated. And second, the action must be one of which rights or obligations have been determined and from which legal consequences will flow. So in other words, again, under this case law, it does not become final until the appeals process is ran. So the Attorney General's office has amended their stance on this process, which actually solves our reason for being here. Now, one thing that our bill that Representative Kendrick has proposed to us kind of cleans that language up a little bit, so it's not so open to the interpretation. Now it clearly states that that final action is not consummated until the appeals process is ran. None of this is intended to cause undue hardship on anyone, but we're talking about people who are not, these are not disciplinary issues. These are issues where officers have been charged with serious crimes that could result in prison time. I shudder to think what would happen if one of these officers who is under a sanction of revocation goes out and gets another job and commits a similar act at that point in time. We're going to look very inappropriate at that point in time. If that makes sense?
Could I
Sure.
follow up?
Yes, ma'am.
Is there any national, this is just for my curiosity, base so that they couldn't hop across the line and go to Tennessee or South Carolina? A clearinghouse, I guess.
Not currently. I sit as a member of the International Association of Directors of Academies. And I sit on that board, and we are working on what's called a National Decertification Index right now. It started under the previous administration, and President Biden has continued with that. We're making a lot of groundway with that. We have a voluntary system right now, but generally speaking, in law enforcement, any department worth its salt would do a background check on whoever they hire, and they should find that. However, it is our intention that this process that you just mentioned will be up and running very soon.
Thank you.
Thank you, sir. Representative Crowe.
Thank you. Thank you, Director Ayers,
Thank you, sir.
for clearing that up. Just to re-clarify for me, so you're saying, and I've been a member or certified by Post since 1996. Fortunately, I've never had any of these encounters, so I'm not knowledgeable about them. But if you have an officer who is charged with a felony, you can do an emergency suspension, and then you can revoke their certification. But during the appeal process, you can keep the emergency suspension in place.
That is the way it is. The AG's office is telling me that the law should read now.
Okay. So you can, so even though they're appealing the revocation, you can keep the emergency order in place per their current interpretation until that final decision or their final appeal is done,
That is
which would
correct.
keep what you were worried about happening from happening.
Absolutely. Yes, sir.
This bill, though, would clean up that language and leave it less subjectivity in
Yes,
case
it would.
another AG has a different interpretation someday.
Exactly. Or, as again, we're dealing with issues where at this point in time, most officers, of course, do have attorneys.
Mhm.
at that point in time. So if you give, as you know, an attorney any room to argue something, they're going to argue that issue.
Yes, sir. Okay, thank you.
Yes, sir.
Thank you.
Thank you, sir.
Any other questions? Yeah. Representative Jackson?
Thank you, Mr. Chairman. And this only applies to felonies, not misdemeanors too?
Yes, sir. Just felonies, sir.
Just, okay.
Thank you. I'm confused on one thing, emergency suspension.
Yes, sir.
Explain that to me in the law enforcement field.
Yes, sir. It's covered by code section, and that code is Georgia Code 35-8-7.2. And what it does is it authorizes me as the executive director to sign a order
Okay.
which prevents that individual while they are under investigation for a felony charge to, it's basically a cease and desist order. In other words, you have no law enforcement authority while this is underway. This is very different than somebody who is being investigated, say, for a use of force issue or anything in the investigative process. This only attaches when warrants have been signed for that individual's arrest.
So this is just for, it's not an allegation.
No, sir. These are charges.
These are charges. That's the
Yes, sir.
reason I want to get it in my mind.
Yes,
The
sir.
difference of the two.
I have to attach the actual copies of the warrants to that document.
Yeah, because I just saw where it said that it was an emergency suspicion based on allegation of something happened. But you're saying this is,
I cannot do anything until a warrant has been signed and
warrant,
issued by a
okay.
judge. That is correct.
okay, all right.
Let me clarify, because I think I'm the one that said allegations, and maybe that's just the lawyer in me talking.
Yeah,
But when I say allegations, it means that a final adjudication has not been made. So
Sure.
in my mind, that's what allegations means.
I just wanted to be clear that, allegations are one thing, and we got, I want to protect both sides.
Absolutely.
That's what I want to
In
do.
this particular matter, probable cause sufficient to issue a warrant and
Okay.
a warrant being issued
Okay.
is required before we can take that action.
Thank you very much.
Yes, sir.
Anybody else got any questions? This was a hearing only. We appreciate you coming. Do you have anything else to add?
Nothing other than to thank you for your time, sir.
Well, thank y'all for coming. We appreciate that very much, Representative. Thank you. Have a motion to dismiss them. Second. All right, let's go. I got